Hi everyone, and welcome to another one of our webinar series for the year. So today we've got Julie from Tenants Queensland talking about when violence affects your tenancy. So I'll go through a little bit of housekeeping first, and just before we get started, I'd like to acknowledge the traditional owners of the land on which we are holding the webinar today. So in Brisbane, they are the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. So today, this webinar will be viewed by people across Queensland and Australia. So I'd like to pay my respects to the traditional owners of the land throughout the country and acknowledge that there's still much to be done in terms of achieving reconciliation. So my name's Carly, I'm from Community Legal Centres Queensland, we'll basically get started straight away, but first I'll just let you know that there are a couple of ways you can ask questions throughout the webinar. So the first way is by pressing the button that looks like a hand. We'll see a hand go up on our end, and then we can unmute you and you can ask your question verbally. The other way to ask a question is probably the easier method, and that's just to type your question into the question box on your control panel. So we'll probably hold questions over to the end, but if you do have any issues throughout the webinar, we had some tech problems last time, so please do let me know by using the questions box or by sending an email or calling into the office if you have any sound problems. So I'll hand over now to Julie, who will take it from here. Thanks, Julie.
Thanks, Carly. Hi, I'm Julie Bartlett. I'm from Tenants Queensland, and the topic for today is called When Violence Affects Your Tenancy. So I'll be talking mostly to this slide, but I'll be expanding on some of the slides and answering questions throughout. The two main, I guess, stakeholders or bodies you'll be dealing with in relation to a tenancy dispute would be the RTA and QCAT. The Residential Tenancy Authority holds the bond. It's a statutory government authority and it administers the Residential Tenancies and Rooming Accommodation Act. They provide the forms, the approved forms under our legislation, and they provide information to lessors, tenants, agents and residents and providers. They also conduct a dispute resolution service and they investigate complaints of unlawful conduct under tenancy law. Dispute resolution is quite an important process, it's quite an important step to remind your clients of. So we'll get into that a bit later. QCAT, the Queensland Civil Administrative Tribunal, is the main jurisdiction tenancy disputes are determined in. It replaces the old small claims tribunal. And as some of your listeners may or may not be aware, domestic violence is heard in the Magistrates Court. Occasionally, you can raise these issues in the Mags Court whilst you're dealing with a protection order. QCAT, the aims of QCAT is to resolve tenancies dispute in a way that is fair, just and equitable. It's a tribunal, and whilst it doesn't adhere to the rules of evidence, it needs to allow the parties to present evidence during the matters, and the parties must represent themselves. However, there may be instances where clients can get leave for another person to represent either a solicitor or a tenant advocate or community worker. So the topics we'll be talking about is domestic violence. We'll go over the definition a little bit. We'll talk about ending or changing tenancy agreements. We'll be talking about debt disputes and tenancy databases. The definition of domestic violence is contained in the Domestic and Family Violence Protection Act 2012. It includes behaviour by the first person towards the second person with whom the first person is in a relevant relationship. That behaviour needs to be physically or sexually abusive. It can be emotionally or psychologically abusive, economically abusive, threatening, coercive, or they mean to control the other or dominate the other person. That makes them fear for their safety and well-being. So that definition is expanded upon in the Act, and there is a bench book, and I'll give you a link to that bench book towards the end of the PowerPoint that goes through the provisions under the Domestic and Family Violence Protection Act, and it may touch on relevant cases. Whilst it's not necessarily related to tenancy law, it is something your workers may want to look at when assisting clients in this circumstance. So domestic associate, under our legislation, we follow the definition in the Domestic and Family Violence Protection Act. Domestic associate can be in a spousal relationship, an intimate family relationship, intimate personal relationship, a family relationship, or informal care relationship. Those provisions are, those definitions are mirrored in the Res Tenancies and Rooming Accommodation Act. And if you're wanting a more expanded definition of what a spousal relationship or intimate personal relationship, etc., is, I would refer you to the Domestic and Family Violence Protection Act and the bench book, where I've got a link at the end of this slide. So key questions if you're assisting a tenant who's experiencing violence is to ask them what their relationship is with the perpetrator or the other tenant, whether they're a domestic associate or just a co-tenant. Also, does your client want to stay or leave the rental property? And you may also want to know the status in regard to the tenancy agreement, whether they're an occupant, a tenant, or a co-tenant. And they're the questions you'd want to have in your mind that would assist you in figuring out which way to advise your client. So some of the things QCAT must consider before deciding on an application. In deciding on an application, QCAT must consider whether the applicant has applied for a domestic violence protection order against the offending tenant and the conditions of that domestic violence protection order, such as whether or not there's an ouster and any other conditions. If the applicant is not a tenant, whether the applicant is a domestic associate of the violent tenant or an occupant, whether the applicant lives at the premises. In an application to add a person's name as a tenant, whether the property owner agrees to add that person, whether the evidence proves the applicant has suffered or is likely to suffer domestic violence. Also, QCAT doesn't always have to consider the circumstances of the property owner. However, we do recommend that you add the property owner as a respondent to any application, as they're going to have to follow through with any order to remove or add a tenant. So the next slide, evidence to support an application. The applicant must provide evidence to substantiate their application, such as copies of protection order, photos of injury or damage. Often tenants won't think to take photos of injury or damage, but as you may be aware, the Queensland Police Service, if they attend the premises, may have already taken photos, so you may want to consider a right to information or consider gaining access to those photographs for your client. Proof of occupancy, such as a tenancy agreement or any other agreement, witness statements, bank statements showing financial hardship, especially if your client is considering undertaking an excessive hardship application. When making an application to QCAT, applicants must ensure that they name all the parties on the lease. So we often advise to name co-tenants or other tenants on the lease, as well as the property manager or lessor of the property. So ending or changing a tenancy agreement. If you're a domestic associate and you want to stay, or your client's a domestic associate, and if you're a domestic associate or occupant and you occupy the premises with the tenant and the tenant causes serious damage to the premises or commits an act of domestic violence, you can apply to QCAT for an urgent hearing. Urgent hearings currently in Brisbane take between 3 to 4 weeks. In the regions, urgent hearings could be less or could take a bit longer. We normally advise you ring your local QCAT, which operates out of the magistrate courts in the regions and operates out of Queen Street in Brisbane, to get an idea of the listing times or hearing times. A domestic associate of a co-tenant may apply to the tribunal for an order recognising that, having themselves recognised as a tenant or co-tenant instead of the domestic associate. And I'll have a slide about the forms a bit later. So occupant. An occupant is not a tenant or a subtenant. Sometimes they're just listed on the general tenancy agreement as a person that may occupy, and sometimes they're not listed at all. It's just, there may just be reference to the numbers of people that can occupy a premises. So under 246, they can apply. Again, I think that's an urgent application to QCAT, and they can apply to get recognised as a tenant instead of the perpetrator. If your client is a co-tenant or a subtenant, they're legally allowed to stay at the property. However, there's no application they can make to have the perpetrator's name removed as a tenant. A domestic associate, if they want to terminate, they would again use the provisions of the Res Tenancies and Rooming Accommodation Act, QCAT Form 2, and apply under Section 321. Application by the tenant's domestic associate for termination for damage or injury because the tenant has intentionally or recklessly, or is likely to intentionally or recklessly cause serious damage to the premises or has committed domestic violence against the domestic associate. I would imagine you would need police reports or good evidence of the likelihood of further damage occurring in the premises, and photographs would be useful here as well. If the occupant wants to terminate, if you're an occupant and you want to terminate, Section 322 of the Res Tenancies and Rooming Accommodation Act would be the section you'd apply under. An occupant of the premises, which, a person who's not the tenant, may apply to a tribunal for a termination order because the tenant has intentionally or recklessly causes, or is likely to intentionally or recklessly cause serious damage to the premises or injury to the applicant or someone else. Note that an occupant is not named on the lease, and we went through that a bit earlier, and they're not legally liable for the tenancy. An occupant can leave any time. They're not liable for the damage to the premises. And yeah, this is an unusual provision where unclear why an occupant would use this. We're just figuring it may be a way people can minimise further damages claims by ending the tenancy agreement outright through an application to QCAT. A tenant, a co-tenant wants to terminate. Tenants can apply to QCAT for an urgent hearing to terminate their tenancy under the following sections. So there's excessive hardship provisions of the Res Tenancies and Rooming Accommodation Act, and there's the Section 312 damage or injury by a co-tenant. So the excessive hardship provisions, it allows QCAT to terminate for excessive hardship isn't defined in our legislation, so it'll allow QCAT to terminate for financial hardship reasons, plus domestic violence may fit in with the ambit of excessive hardship. and it may allow a lessor agent to come back at the tenant for potential compensation for terminating agreement early. However, there are ways to mitigate against a compensation claim, and we'll go through that a bit later. A damage or injury by a co-tenant, again, that's an urgent application to QCAT. So if the co-tenants are listed on the tenancy agreement, list them as respondents. If security is a concern at QCAT, security officers may be able to prevent certain persons from entering the hearing room, and also you may request that QCAT keep hearings private or not open to the public. So restraining orders. So a domestic associate or occupant may apply to a tribunal for an order to restrain the tenant from causing further damage or injury if they believe on reasonable grounds that the tenant is likely to engage in the above behaviours. So we don't often see tenants using this provision. Tenants will often apply to terminate for obvious reasons and leave that tenancy and try to reduce any potential damages or compensation claim against them. So how to apply for one of the orders mentioned previously? You would apply to QCAT. You'd use a Form 2. It's an application for minor civil disputes. You'd provide 3 or 4 copies. In Queensland, QCAT requires you to provide copies for each respondent plus the applicant and one for QCAT. But QCAT will serve the Form 2. The application is an urgent hearing. The listing times vary, however, expect 2 to 3 weeks. The listing times will vary depending on the type that, if you're at the end of the year, the listing times will be a bit longer. So we recommend ring your local registry to get an idea of listing times. If you can't get a urgent listing time in your area, the QCAT Act does allow you to apply to Brisbane. So you could apply to Brisbane, or you could apply for a hearing in the area closest to the rental premises. So if financial hardship exists, you may apply for a fee waiver using the QCAT Form 49. And if there are other tenants, co-tenants listed on the tenancy agreement, we advise to list them as respondents, and QCAT will serve them along with the lessor agent. So again, if DV is a reason for ending the tenancy early, it's a good idea to attach evidence such as protection orders, police reports, affidavits from health providers or support services, photographs. Tenants Queensland also have a series of DVDs in relation to QCAT and the process. So it would be advisable if your client's a bit anxious about the process to let them watch the DVDs, or because QCAT is it's open to the public, sometimes we do advise tenants, if they feel up to it, to sit in on 1 or 2 hearings to get an idea of how QCAT is run. And I've just put a graphic of the QCAT form. It's the Form 2. The form's about 11 pages. So the first 4 or 5 pages are the relevant pages. It is based on sections of the Act. So you will need to be quite clear in relation to the section you're applying under. So we do have a help desk service at Tenants Queensland, and I'll have the number in one of the slides towards the end. So if you're wanting further assistance in completing these forms for your clients, don't hesitate to ring our help desk service. And here's another graphic from one of our fact sheets, and it just explains what I have gone through briefly in the beginnings of this presentation, and it kind of explains the avenues your client may want to use if they want to stay or if they want to leave. It all depends on whether they're a domestic associate, whether they're sole tenant, a co-tenant, or occupant or subtenant. So this kind of breaks it down. And I think we're in the middle of updating the when violence affects your tenancy fact sheet. So that should be updated within, I'd say, a few weeks. So we'll move on to debt disputes, unless there's any questions. No. Ending tenancies, right. So I'll just give you some general tips, because we normally find in relation to tenants, if they don't have sufficient evidence or if they don't end their tenancy agreement correctly, either by giving written notice, such as the form RTA Form 13, or seeking a termination order from QCAT, the next issue they'll be dealing with is a potential debt dispute that results from not terminating their tenancy correctly, or terminating it early, or the lessor agent choosing to pursue a debt rather than forgive a debt due to the circumstances. So I guess the first tip is to terminate it correctly with the proper notice through a termination order from QCAT, to pay rent to the final handover day and ask for copies of the rent ledger. Leave the place clean and in the same condition in relation to the start of the tenancy, except for fair wear and tear. A tenant should be given a Form 1, which is an entry condition report, and that's quite good evidence for the agent lessor in relation to the condition of the premises at the start of the tenancy. However, a tenant will need to provide evidence of the condition of the premises at the end of the tenancy. So the tenant has the onus to fill in and complete an exit condition report, which is a Form 14A. They reconcile it with the entry condition report and keep a copy, because that's their evidence. Often when a tenant fails to have evidence, such as taking photos or keeping receipts or completing an exit condition report, that's where they kind of find themselves in a bond or compensation dispute. We advise to return the keys promptly to the lessor agent. Take photos of the keys you handed in, because often at the start of the tenancy, a lessor agent will give you an inventory of keys. Sometimes they give you a photograph of all the keys they've handed you, so it would be prudent to take photos. I understand in these circumstances, this is the last thing a client would want to think about, but it's just something a worker may want to think about when they're assisting a client. So a tenant can lodge a refund of the rental bond, RTA Form 4. That bond can be claimed by either party. It is often released with an agreement between the parties. If the parties can't come to an agreement, then a notice of dispute would be sent into the RTA once the parties received a notice of claim. The RTA will give a person 14 days to send in a notice of dispute resolution. If the parties can't come to an agreement about how the bond is to be released, then the party who's applied for the dispute resolution will get a notice of unresolved dispute, and they'll have to apply to QCAT to get a determination on how that bond is released. Often, if a party hasn't responded to a notice of claim, the RTA will pay out that bond to the person who's made the claim because of the 14-day time limit, but it doesn't prevent someone for applying for a dispute resolution or a notice of unresolved dispute to claim that bond later on in QCAT. There are just a few tricky timelines in relation to claiming bonds, and they are explained on the form, but you can ring our help desk and we can go through them with you. Also, if you terminate agreement before the end of the fixed term of a lease, your lessor or agent may seek compensation from the tenant or tenants. So tenants are jointly and severally liable for the lost rent income, possibly reletting, breaklease fees, advertising, but they're not a given. They're all subject to the lessor's duty to mitigate loss. So the lessor's duty to mitigate loss usually kicks in once they sustain that loss, like when the tenant hands over the premises or when the tenant stops paying rent. So a tenant has the onus to prove failure to mitigate loss, so we often advise a tenant in a break lease early termination to keep a watch of how that premises is being advertised, relet. Did they increase the rent? Did they take weeks to advertise, etc.? In these circumstances, it may be a bit difficult to put a premises straight on the market, given there may be, in some cases, there may be some damage, but part of mitigating loss would be to get the premises repaired and available for rent sooner rather than later. So additionally, compensation claimed by the lessor could be linked in with a bond on break lease costs. So if you do a good, I guess, exit condition report, if you claim your bond unilaterally and put the onus on the other party to dispute, it may be easier to set off a bond against any compensation claim. So often just say we're breaking the lease, you will have two components to your compensation, the bond component and the compensation component, and you can potentially set off the bond against any compensation. It just depends on the state of the premises and the type of evidence you've got available to you. Again, I'm not going to go through this. We've just gone through bond refunds, but there is a 6-month time limit in relation to breaches of agreement or alleged breaches of agreement, such as repairs, cleaning, break lease costs. So it would be prudent if you have a client in this type of situation to do a clear chronology and ascertain when any damage occurred, when they left the tenancy, when breach notices were given, because these are all quite relevant due to the 6-month time limit. So the next slide, dealing with tenancy and disputes and debts. So it's important to deal with tenancy disputes when they happen. Unresolved disputes can result in bond and compensation claims when tenancies end. So you solve disputes when they arise, you gather evidence, seek advice, talk to the other party. You can use the RTA dispute resolution service to do that. I often advise tenants to use the conciliation process to get a conciliation agreement in writing, to get evidence from the other party of what they're claiming, their quotes, their invoices, etc. So if you can't come to an agreement, ultimately in relation to debt, tenancy related to debt disputes, it could end up in QCAT for a final determination. So these are non-urgent disputes. So the listing times for bond compensation disputes can be 6 to 8 weeks. So we always advise to keep copies of any evidence, such as your tenancy agreements, your notices, photographs, etc. And we advise to contact the RTA and claim your bond as soon as possible, as soon as you move out. And again, I'm reminding you of the 6-month time limit. However, there have been some instances where certain debts, such as rent arrears, could attract a 6-year time limit. So there's a typo there. So disputing rent arrears is often a debt tenants are faced with, and it is prudent once you get a tenant in your office and they're wanting to dispute rent arrears, you would request a rent ledger in writing. The lessor agent will have 7 days to provide the ledger, and we often advise the tenant to draft up their own ledger. I know it can be a hassle, but if you're faced with an adjudicator who's looking at a typed up ledger by the lessor or a few receipts and bank statements from a tenant, they really want their evidence presented in a logical, sequential manner. So we would draft up our own ledgers. We have rent calculators here, so it's not an arduous task to do a rent ledger, but it is an important step to dispute a rent arrears claim. So you would dispute in writing, and you would follow up with the RTA Form 16 dispute resolution request to get some conciliation on the matter. So if the co-tenant perpetrator owes money, a possible minor debt application may be where your client would be heading to recover that amount of money from the co-tenant. So if rent arrears is over above the bond, we often advise that you request that the tenant is not listed on a tenancy database given the circumstances, and there are a few sections in the Res Tenancies and Room Accommodation Act, which we'll go through when we hit the tenancy databases section that I'll guide you to in relation to this process. So disputing damage to premises. So we advise keep copies of evidence such as entry exit condition reports. This is what that's the main evidence QCAT would look at in the first instance. Take photographs. You would have affidavit evidence if you don't have photographs, or the Queensland Police Service may take photographs if they were in attendance. Again, use the RTA dispute resolution process to dispute the lessor's claims. Get your own quotes and your own invoices in relation to any damage done. Think about depreciation. If damaged item is old and due for replacement. If an insurance company is pursuing the tenant, often a lessor would file a claim with their landlord's insurance. You may want to consider the financial hardship provisions under the General Insurance Code of Practice, and I do have a link in a following slide about that. And disputing breaklease claims. Again, the lessor agent has a duty to mitigate loss and act reasonably. The tenant has the onus of proof of failure to mitigate loss, such as keep copies of advertisements, correspondence. The lessor can't act unreasonably and refuse to sublet or transfer a tenancy. And again, we request that you advise your client utilise the RTA dispute resolution service to negotiate full and final settlement rather than just release a bond, hoping that that's going to make any claim from the lessor go away. We would always advise only release the bond if you've got some sort of conciliation agreement for full and final settlement for the rest of a potential claim. So here's some, I guess, hardship resources. Some of you may already be aware of these. There is a couple links here to, I think it's a HES scheme, Home Emergency Assistance Scheme for one-off emergency assistance payments in relation to energy. So it would be electricity bills. I think it's $720 once every 2 years. So the form's a bit difficult to find. So one of those links, the QCOS links, takes you directly to the forms, but you have to go to each energy supplier that your client is linked in with through contracts and figure out what their hardship policies are. And often on their websites, they should have a link to this form, but if their websites don't, because I've come across a few websites that don't actually link the forms, I've put the QCOS link to the form. And I've also put the link to the General Insurance Code of Practice hardship provision forms. There is a form you fill out and it would assist your client in relation to a damages claim against them. It would prevent the insurance company from pursuing them. And again, your workers may already be aware of these. Other links, one is the Centrelink crisis payment. It's a one-off payment, and domestic violence is one of the reasons for the crisis, or one of the potential reasons to be able to gain access to this crisis payment. And I've put in a link for that, and the Financial Council's referral from Financial First Aid Hotline. There's a hotline, so you may want to send your client there for further assistance if they're facing a debt dispute. And the next slide's tenancy databases. So a definition of a tenancy database is a database containing personal information that is related to or arising from occupation of a premises under the residential tenancy agreement. So it's not intended to be an internal database. So the most common tenancy database we come across is Ticker, but there are quite a few tenancy databases linked to debt collectors out there at the moment. So some quick facts on tenancy databases. So tenants can be only listed by agents and lessors for a lawful reason. And those reasons are listed under our legislation and our regulation. So tenants can only be listed after the tenancy has ended, not prior. So if that happens, be sure to either ring our help desk for further advice or to flag that, because it may not be a lawful listing and you can dispute that in various ways under our legislation. Only tenants named on the agreement can be listed. So if an occupant wouldn't be named on the agreement, so they can't be listed on a tenancy database. So tenants must also be informed about proposed listings and given 14 days to object to a proposed listing. So tenants can dispute proposed listings or existing listings. Tenants can apply to QCAT to seek removal of listings that do not comply with the Res Tenancies and Rooming Accommodation Act, or if the listing is unjust. So tenants must not be listed for more than 3 years. After 3 years, database listings should be automatically removed. When applying for rental properties, agents must notify tenants if the agent becomes aware that the applicant is listed on a database. So if the reasons for, approved reasons for listing would be if the tenant owes money over the bond amount and there is a QCAT order or some sort of conciliation agreement that you would get through the Res Tenancies Dispute Resolution Service, and that they would be evidence of a outstanding debt. If this doesn't occur, you can always dispute a potential listing for money owed over and above the bond by stating that there were no breach notices, there was no QCAT order or conciliation agreement. So also if a tenant abandons a premises and there is a QCAT order for outstanding debt over and above the bond is another way a tenant can get listed. Or the tenancy, during the tenancy, the tenant was given a breach notice for rent arrears and they did not remedy the breach prior to ending the tenancy. So the rent arrears would have to be in excess of the bond. So again, it would just be more than just an allegation. There should be some evidence of the amount owed and it needs to be above the bond. So additionally, if QCAT has made an order to terminate the tenancy for objectionable behaviour, or the tenancy was terminated for repeated breaches, a tenant can be listed. So to dispute database listings, we advise a tenant to write to the agent and database operator and request removal in 14 days. Tenants can also apply to QCAT for an urgent hearing to seek and that order they would seek for the listing to be removed. It would normally be under section 461 of our legislation. An unjust listing would be the most common in this circumstance. And to apply to QCAT, again, you would need to fill in the QCAT form 2. It's an urgent hearing. We advise to list or to put both the listing agent and the database operator as respondents, so they both get copies of the order to remove the listing. Attach a copy of the listing, so you would have to obtain a copy of the listing either from the database operator or the listing agent, or you would attach evidence of the proposed listing if you're applying to prevent a listing from being made. So you need to state why the listing is unlawful, incorrect, ambiguous, unjust, or out of date, and why you believe it should be removed. And we do have comprehensive fact sheets on tenancy databases that will take you through this process. So again, we state that you request the order that the listing agent and the tenancy database immediately remove the listing. So here are the various sections you would apply under to have database listings prevented, or proposed database listing prevented, or to have database listings removed. So section 462 you would use to dispute a proposed database listing. Section 460, if the listing is in breach of the listing rules, you must apply within 6 months of becoming aware of the listing. And section 461, if the listing is inaccurate, incomplete, ambiguous, unjust, or out of date. And those definitions are included in our fact sheet. And under section 461, you can dispute or remove an unjust listing if the tenant was not involved in the act or omission that led to the listing. Again, domestic violence is falls within what an unjust listing could potentially be. And you would also put in evidence such as an affidavit that would assist you in explaining to the tribunal that the tenant is suffering homelessness or severe hardship due to the current listing. Some tenancy database tips would be to obtain a copy of your listing, obtain a copy of that listing from either the listing agent or the database operator. Use your QCAT form 2. Even it's an urgent hearing. You don't need a notice of unresolved dispute from the RTA dispute resolution service. You would most likely need 4 copies, one for the listing agent and the database operator. The filing fee is $25.45, or you can apply for a waiver of fee. And you would need evidence of the debt paid, or evidence that the listing was unjust. So here are some contacts. So I think we're coming to the end of the slide. So I've got contacts for tenancy advice. Our advice times are 9 a.m. to 5 p.m. Monday to Friday, and we do have evening advice sessions. And I have a link to our fact sheets and information, and link to our QSTARS fact sheets information, link to QCAT, and link to the Res Tenancies and Room Accommodation Act, and links to the RTA. So additional resources I've put in the MAGS Court, Queensland Domestic and Family Violence Protection Act Bench Book. There are some useful cases in there, and the Queensland Police Services Operational Manual. So I think I'll hand it over to Carly if she's still there.
I am here. So thank you so much.
Yeah.
It's really informative. I think a lot of information, and really great to see, you know, all of the actual detail that our workers will need when they're responding to clients who have issues around tenancy that might be caused or related to domestic violence they're experiencing. So we will now throw to some questions from our audience. So I'll just remind you that there are 2 ways you can ask questions. You can either press the button that looks like hand, and we can unmute you, and you can ask your question via your microphone. Or if you like, you can type your question into the question box, and we'll read your questions out, and then Julie can respond to those. So hopefully everyone is wildly putting their questions in. We do have one here already, so I'll just read that one out for you, Julie. So how do tenants dispute proposed listings once given 14 days notice? What's the process suggested? And you may have already covered that. I'm not sure.
Yeah,
yeah.
I did. It was in the slides. It's section 462. You would, I guess you would create evidence by writing to the listing agent explaining why you shouldn't be listed. And if they still insist on listing you, you would have to either apply to QCAT under the section 462 of the Act to prevent a proposed listing. You could use the RTA dispute resolution process potentially, and a conciliator may come up with some sort of conciliation agreement that may prevent them or convince them to not list you. But ultimately, if you're wanting to definitely stop that listing because, you know, that they may say, we're not going to list you, and 6 months later, they may list you. A QCAT order would be the way to go. And again, that would be using the QCAT form 2 and putting that listing, prospective listing agent, you know, that they would send you correspondence saying we're proposing to list you. You would dispute it. And if that doesn't prevent them from listing, you would have to go to QCAT under an urgent application.
Okay, so a couple more questions coming through, and I'll just remind everyone that we do have a copy of the slides. A copy was emailed out to everyone this morning. It's also listed in the handout section of the GoToWebinar control panel, so you'll see there a copy of PowerPoints that you can download, and we'll also be popping those up on the Community Legal Centres Queensland website this afternoon, along with a of domestic violence. Can you at least get the lease terminated because of the DV?
Gosh, you can, if you're co-tenants, to agree to that termination. So we're talking about a contract here. All, you know, the lessor agents are party to the contract, and the two co-tenants are the party to the contract. You're all jointly and severally liable as co-tenants. We have had tenants apply under the excessive hardship provisions, but they normally work when there's a sole tenant, and that's solely responsible for dealing with that premises. So I guess it's through negotiation. That would be the main way you would try to get the tenancy terminated. I suspect if the other party is still not wanting to come, you know, to agree to have the whole tenancy terminated, there is a provision under section 312. You can try to end your responsibility under the tenancy agreement because there's damage or injury, and you name the co-tenant and the lessors as a respondent, and they were in the earlier slides. But that that may not totally absolve you from any liability. It all depends on the agent or the lessor in relation to how they're going to deal with the situation. Some lessors and agents may not pursue against one tenant and choose to pursue against the other. So these are unknown factors. There's no legislation in relation to domestic violence that would prevent a lessor or agent pursuing both tenants equally, except a potential QCAT order that will remove one tenant. And I think possibly 312 would be where you'd head to try to get your name off the lease. Does that answer your question?
Hopefully. So another one's come through following on from that one. So asking what the benefit of having a domestic associate or occupant recognised as a tenant if they cannot get the perpetrator off the lease agreement.
345 is where the domestic associate may apply to be recognised as a tenant or a co-tenant. I guess the benefit is the ouster order where you've gotten the tenant removed from the premises for the 12 months or 2 years, depending on your protection order, and you want to remain. So that's where you would utilise the domestic associate taking over the tenancy provision.
Okay. So another question has come through, Julie. So if the co-tenant is a victim of domestic violence and for safety reasons she or he was forced to move away from the premises, how does the real estate usually respond? So do you have any advice about exactly what the victim should do in those circumstances?
Gosh, we're dealing with people here. It's I guess the agent and the lessor's their call, their conscience. Often tenants will offer up a copy of a protection order or a police report. It's really hard to gauge without knowing a particular agent how they've acted in the past. So some agents will just pursue one tenant over another, or some lessors. They may end up getting an order against both, but they may pursue one against the other. There's no legislation at this stage. This is kind of why I've placed all those financial hardship resources, because what can usually happen is they'll get an order against both parties, and they may not be able to recover the monies. They may make a claim. This is a lessor may make a claim against the landlord's insurance, and then a few months later or a year later, an insurance company tries to pursue against both parties. And yeah, it's really hard to say yes, definitely. Lessors and agents will not pursue one tenant over another, because it's up down to their personal business practice and what sort of insurances and what sort of coverage they have that they can access. So yeah, I guess evidence is the key. Using the RTA conciliation dispute resolution process is another key to try to negotiate and reduce the amounts claimed. Taking your photos, doing a good exit report, those sorts of things. So I guess utilising a dispute resolution process may be of assistance, and possibly bringing the matter on in QCAT to prevent the matter being taken somewhere else, like the MAGS court, by an insurance company, which could be a cost jurisdiction, which could have other fees attached to it. Maybe a way to go, but I do have access to our help desk service. You do have access to our help desk service. I did put in a phone number in one of the slides. So yeah, QStars and Tenants Queensland can give you help desk advice in those circumstances.
Fantastic. So one of our listeners is just sort of acknowledging that there really seems to be a gap in that area, and a gap in the legislation in knowing how to really respond appropriately to issues around domestic violence and tenancy. And potentially that real estate agents may not really be prepared for that kind of situation arising and may not know how to deal with it. So as you mentioned, it really does come down to the individual real estate agent and the owner of the property and their conscience, hopefully. So one last question that's come through is that it's regarding databases. So if the agent doesn't inform the tenant of the database listing and the tenant finds out at a later stage, who has the onus to show that the tenant was informed? Can an agent claim they didn't have a forwarding address? And would that make the database listing void?
Often agents do claim they don't have a forwarding address. There is a provision in our Act that does state the tenant should give the agent their forwarding address if requested. So I know QCAT accepts service on the last known address, the residential premises, expecting a mail redirection. So whether or not QCAT, follows that through with agents. So yeah, it does happen. There's no great onus in relation to forwarding addresses on the agent, less or to ensure that they're all up to date and correct. They can ask the tenant, but if the tenant refuses, agents will often just send it to the last known address expecting a mail redirection. So I guess it would be an application to QCAT to get that database listing or proposed listing prevented through an application.
So if tenants don't, if they have already vacated the property and don't have a mail redirection on and never received that letter, I suppose what will happen is that the next time they apply for a rental property, they'll be told that they have been added to the database. Would that be correct?
Yeah, that they should be notified, and then they get a copy of the listing and they can apply to have it removed for being an unjust or possibly incorrect, depending on the circumstances.
Okay, lots of really interesting stuff there, and particularly around that database information. That's pretty new to me and something that is really important for our clients who are tenants, I think, to be aware of. So certainly that part has been really helpful for me personally. So I think we've got just a couple of thank yous that are coming through. So I think we might be able to wrap up now. So from everyone who has tuned in today, thank you very much, Julie, for your fantastic presentation and that really helpful information that our members can now pass on to their clients. So thanks so much, and tune into our next webinar series. Thank you, everyone. See you later.